Parles-tu français? Hablas español? Parli italiano? If you've used Babbel, you would. Babbel's conversation-based techniques teaches you useful words and phrases to get you speaking quickly about the things you actually talk about in the real world. With lessons handcrafted by over 200 language experts and voiced by real native speakers, Babbel is like having a private tutor in your pocket. Start speaking with Babbel today. Get up to 55% off your Babbel subscription right now at babbel.com/Wondery. Spelled BABBEL.com/Wondery. Rules and restrictions may apply.
Welcome to Law and Chaos. Today, we've got an interview with Lawfare's Anna Bauer, who's here to answer the burning question, who is the administrator of DOGE? We've got a lot to cover, so let's get after it. Hey guys, I'm BlueSky, and with me as always is Andrew Torres. Andrew, how are you?
I am great, Liz. I am super excited to welcome back one of our favorite guests, Anna Bauer of Lawfare. We have been talking to her since her outstanding work covering Trump's criminal indictment in Georgia.
Those were the days.
Yes, they were. So everyone should be following Anna Bauer on social media and, of course, reading her work over at Lawfare.
Absolutely. All right, let's get to the interview. And with us today is Anna Bauer, senior editor at Lawfare, here to discuss Elon Musk, her villain origin story, and all things DOGE. Anna, how are you?
I'm doing well as one can right now, Liz.
Yeah.
Thanks for having me.
It's wild. I'm so glad you're here.
Well, thanks for coming back.
Okay, before we get to DOGE, can we talk for a second about something that happened in the Second Circuit today as we are recording this? It'll air a few days later. But what happened is that Donald Trump took another swing at disappearing the criminal indictments against him that came down last year in New York, the false business records case indictments.
Yes, yeah. And the Second Circuit heard oral argument on that today. So just a brief refresher for people who don't remember what's going on, because it feels like it's been a decade since Donald Trump was convicted on 34 felony counts for falsifying business documents in New York. But since that case, since Trump's conviction in New York State court, the Supreme Court soon after came down with its immunity decision. And importantly, in that decision, one of the things that made it so shocking from the Supreme Court is that there's a section of the opinion that says basically, even in cases that aren't about the president's official conduct, where the president isn't technically being charged for that official conduct, you still can't bring in evidence of official conduct to prove up a charge that is about private acts or things that the president did in his, personal capacity that's not official. And so that decision comes down. And previously, before Trump even went to trial, he did this thing where he tried to move his case to federal court. There's this statute that basically allows federal officers who are charged with conduct related to things that they did under the color of their federal office. It allows them to move those charges to federal court and the reason for that being that, there was this old idea that maybe state juries would be kind of prejudiced against federal officials who are charged with doing things related to their federal acts, in a state because those federal actions might be pretty unpopular in that state. There's also this idea that, a person who can raise a federal defense, which is one of the elements here, that federal defense might be more fairly litigated by a federal judge. So there's all these different, policy reasons behind this statute that allows a criminal defendant who is a federal officer to remove their case to a federal court. Trump tried to do that before the New York trial. The federal judge said no. Then Trial happens, he's convicted, this immunity decision comes out. And based on that decision, Trump then, a few months after he's convicted and after this decision comes out, again tries to go to federal court and says to the judge, even though we tried to do this before, even though there's a section of the statute that says you're supposed to do it within like 30 days of arraignment or whatever.
30 days, yeah.
Even like putting aside all of that, there's a part of the statute that says that you can remove for good cause shown. And they say basically like this immunity decision is one reason why we should be able to remove this case to federal court. There's a bunch of things during the trial that were introduced into evidence that included things like Trump's tweets that he did while he was president, that included things like a conversation that he had with the White House communications director, Hope Hicks, things like
Hope
that.
Hicks testified.
Yeah,
and as did Madeleine Westerhout.
Yeah. And cried during her testimony. And it was this moment that during closing statements, the prosecution said was, devastating in terms of Trump's defense. So even though these charges in New York State court that he was convicted of are things that he did, before he was even president, some of the conduct that they introduced into evidence related to things he was doing while he was in the White House. And so he tries to remove. Judge Hellerstein, again, says no. And then that's how we get to the Second Circuit for these oral arguments that just happened earlier today. Trump's team appeals saying, Judge Hellerstein got it wrong, not even letting them file a notice of removal to try to get this post-conviction appeal into federal court. And so we heard argument today. There is a 3-judge panel, all of them Democratic appointees. And I'm curious for your thoughts on it, guys, because my take on it is that the panel thinks that it was at a minimum that probably Judge Hellerstein should have, instead of just not even considering some of the issues that were being raised in the notice of removal or the attempt to file a notice of removal, that Judge Hellerstein should have, let them file, allowed the district attorney's office to file a notice of remand, to send it potentially to make the argument that it should not be removed, basically, and hold a hearing on it, all of that kind of thing. Instead, what Judge Hellerstein is just say, no, you can't do this. And I think that maybe the court is taking this way more seriously than Judge Hellerstein did, thinks that, the Supreme Court's immunity opinion was very broad, seems to think that the standard in the removal statute, because all you have to do is raise a colorable federal defense, a colorable argument that this is a charge that is related to official conduct. All of those things kind of combined means that the appeals court seems to be taking this more seriously than the lower court did. But what did you guys make of it? Or if you didn't listen to it, I know that you guys have takes on this removal argument in general. So what do you think?
Yeah, I do actually, because I want to parse kind of carefully what Judge Hellerstein did, because the initial, right? So the removal statute is 28 U.S.C. 1455. And so the first time around, Hellerstein made that factual finding, right? Said, as a matter of law, this is not within the scope of presidential duties, right? This is repayments to Michael Cohen, your fixer, for payments that he made on your behalf to adult film actress Stormy Daniels in order to suppress her story before the 2016 election. That's not plausibly connected to the job of president. Therefore, I'm not going to remove. And now the second argument is that the statute says you may file a second petition to remove for good cause, but only on grounds not existing at the time of the original notice. And I think that Trump has a really, really heavy laboring oar to carry there, because they are arguing that they've always had presidential immunity, right? And I don't think you can have it both ways, right? Like, you can't say we've always had the powers that the Supreme Court recognized in Trump v. US, right? Which have been what they've maintained. But also, everything changed after Trump v. U.S., which is the reality. And I don't think the legal inquiry did change, right? Like I understand, I take your point well, that there is that section in Roberts' opinion that says, not only would we not permit criminal charges against a president for conduct related to conduct in office, but we will not admit testimony that would invite the jury to speculate and second guess the president because, Lord knows we need the president to act boldly. You got what you wanted, Chief Justice Roberts. But that fundamental inquiry hasn't changed, right? And if the law hasn't changed and the inquiry hasn't changed, I guess I feel like Judge Hellerstein is sort of getting a bit of a raw deal from the Second Circuit there. Liz, what do you think?
Okay, hang tight. We will be right back after this brief ad break. Yeah, and as I recollect from the proceedings here, it was waived. The argument was kind of waived, that they waited far too long to make the argument. If their theory is, we have always had this immunity, well, they should have asserted it before last summer, which I think was even after the trial, right? After the U.S. v. Trump decision, the immunity decision, or Trump v. U.S., I think was the case caption. After that came down and the Supreme Court really did reorder the pieces on the chessboard, that's when they made this argument about the Hope Hicks testimony being official evidence or evidence of official acts. And I believe that Justice Merchan said it's way too late, but if you had lodged this objection in timely fashion, I'd have overruled it. And since it's so late, I'm going to deem it harmless error. If I recollect, that's the sequence of events.
Yeah, I think that's right to my memory. And I also will note that my recollection is that, and this was brought up by one of the appeals court judges today in the Second Circuit, that, the initial claims that were raised, eventually Trump did, as we've discussed, raise this immunity argument. But initially it was mostly just, supremacy clause immunity stuff and not, absolute immunity, which is what was at play in the Trump case. And so you have that. There's also these other questions that are lurking here that is in this issue before the appeals court. One of them is that, now Trump is kind of raising absolute immunity in the sense that the Supreme Court's opinion in Trump was about absolute presidential immunity. But that specific section that they are referring to, which is about what can be brought into evidence in cases that are largely about unofficial conduct of the president, that's really an evidentiary immunity. And so there's this question, because in the removal statute, one of the requirements is that you have to raise a colorable federal defense. And so there's this question of does the type of immunity you're raising, whether it's a substantive immunity that is a kind of complete defense versus an evidentiary immunity, which is just about, what actually can the prosecution admit at trial. So there's that issue that the appeals court is going to have to resolve. And then there's this other issue too, which is that for the most part, I don't think that there's, and to my memory, I don't think there's any criminal cases that relate to questions of removal to federal court that have occurred after the conviction and sentencing. And typically, again, what happens is within 30 days of arraignment, you're supposed to file this notice and then it gets litigated. Of course, as we've mentioned, there's this other section of the statute that says, for a good cause, there can be this second notice, but it really just, seems that there's this kind of novel issue here related to after someone's already been tried and convicted and sentenced, and under the whole policy rationale of having the removal statute, one of which is that, what's important is getting someone tried in a fair forum. So that is the whole idea, right? Is that you move it from state to federal court for that reason. it's kind of like what's going on in this case where the idea is moving it to federal court for the appeal. But I'm curious if you guys think that ultimately the outcome of this even really matters, in the sense that these issues, this immunity issue, the other things that Trump has raised in his appeal at the state court level, they're ultimately going to try to bring all of those things up to the Supreme Court to the extent that
Mhm.
they can. Um, and that includes this immunity question. And so really, whether or not Trump's case gets removed to federal court, I think just becomes a question of how quickly is this going to get to the Supreme Court? Because otherwise it's going to just work its way through the New York state courts, and then it'll end up going to the Supreme Court eventually. But this is just kind of this kind of just affects how quickly it ends up getting to the Supreme Court. Do you guys
Yeah.
agree?
Well, so I think I want to break it down maybe for non-lawyer listeners,
Yeah.
because there are two pieces that you're talking about. The first is, did he have a right to remove, Trump, have a right to remove this case to federal court in the first place? And that one seems pretty clearly the answer is no. And he did, in fact, get a hearing on that very issue when he tried to remove it, right when he got indicted like 3 years ago. He tried, and as you said, Judge Alvin Hellerstein, who is a federal judge in the Southern District of New York, said no, paying off your, porn star to keep quiet it does not implicate, right, a federal crime. That does not implicate your official duties. It doesn't you don't get federal removal. Go back to state court. And then the trial commenced. And then later there's the separate evidentiary issue. And that's the issue of, after Trump v. US and the immunity decision, could this evidence of his official acts, the testimony by Hope Hicks and the assistant Madeline Westerhout, and the tweets and his, I think it was his financial disclosure, his ethics disclosure, that didn't have the payment which he owed to Michael Cohen on it. The question is, could that come in? And those are sort of two separate issues. And I kind of agree with you, right? The question about federal removal is in some sense just a kind of a dogleg. The real issue, and it is, I agree with you, going to be decided by the Supreme Court, is what to do with the fallout from their immunity decision, which, remember, they sat on that. Remember, that came out the last day of the term in July. They could have put that out earlier and let the trial go before it was already to a verdict. They could have done this thing if they believed that it was settled law. It was a 6-3 decision. And so, this is the Supreme Court reinventing the law, and Trump saying, I get to undo what was done because the Supreme Court has now changed the standards. And I agree with you, right? That the question of federal removal is an interesting sort of side note, because indeed, whatever happens, Trump is going to argue this all the way up to the Supreme Court. And I suspect, as you do, right, I'm not sure what happened today, and I'm very interested in your take as to what's going to happen after today. But I agree with you that he's going to go up to the Supreme Court, and the Supreme Court's going to say, no, this verdict was invalid because Hope Hicks testified, and we said Hope Hicks couldn't testify.
Yeah, and just to clarify a little bit more for listeners who maybe are confused about why I'm kind of lumping in this removal question with this question of this immunity defense that Trump has raised in the wake of the Supreme Court's decision, one of the elements that you have to show when you're trying to remove is that you have raised a colorable federal defense. And so Trump's federal defense that he is raising is this issue of, the evidentiary immunity that comes out of the Supreme Court's immunity decision. And then, they're saying that we didn't know that this was going to, be a part of the Supreme Court's decision and all of that. And so that's why we now have good cause to move this case to federal court to proceed on appeal. Again, the reason why I'm saying that event that kind of just affects how fast it gets to the Supreme Court is that would mean that if Trump's case now is removed, it goes directly through the federal courts, as opposed to first going through the New York state courts, who will consider any of his substantive, appellate issues. And then once those are exhausted, it would eventually, go to the Supreme Court, presumably at least, to decide some of these questions around immunity and all of that, or other due process things that, any constitutional claims that Trump might have raised in his appeal.
Got it.
And we will be back with more with our interview with Anna Bower after this brief ad break.
And we're back. Okay, that was great. Let's move on from the Trump pre-election crazy times to the Trump post-election crazy times. Everyone knows that we asked you here, Anna, because you are the queen of DOGE, not to say the administrator of DOGE. Actually, are you the administrator of DOGE? Anna Bower, are you the administrator of DOGE?
I might be. Stay tuned. My editor thinks that I am the administrator of DOGE. We'll see.
Well, if it's a public office, you picked up 2 more votes here today.
All right. So go ahead. Tell us your villain origin story.
Yeah. So my villain origin story started around the time that these executive orders were issued that created and established the United States DOGE service. And so I'm not sure how much you guys have, I know that you've talked about DOGE, but just to kind of really nail down exactly what DOGE is. There's this executive order that Trump signed on January 20th. And
First day in office. One of the first things that he does is create DOGE. And leading up to this moment, it was really unclear exactly what DOGE was going to be. There's typically this thing that you can use called an advisory committee that is kind of this like panel of outside advisors who make recommendations to the government. And there was a lot of speculation that is what Trump was going to make DOGE be, because he basically said so in November when he announced that DOGE was that he was going to make DOGE. And in all of those public announcements, it was always that Elon Musk would lead this group for a brief period. It was Vivek. Well, and also Vivek Ramaswamy. Yes. Let's pour one out for poor forgotten.
Yeah,
Vivek.
He didn't last long, but Vivek will remember your very brief tenure as the almost administrator of DOGE. But in the lead up to the inauguration, it was always that Vivek and Elon were going to be the people leading this DOGE thing, whatever it was. It clearly wasn't going to be a federal department because...
Right. They said it's going to be outside of government. Trump said that in all of his public announcements.
Right. And also like a federal to create a whole federal agency, whole cloth, you'd have to have some kind of congressional, approval or establishment. And so typically like what the president can do to create something is a little bit more limited. Like I said, you can make an advisory committee. But what they did on...
Yeah. And those are like the blue ribbon panels, right? Like come in and we're going to listen to, a committee of economists tell us on, what should be the official, first day of the, tax year for the government. It's something like that, where they truly are just bringing in expertise in order to provide recommendations.
Yeah, exactly.
Right?
Or and some advisory committees are more, powerful than others. Like, the FDA has advisory committees that are very influential it's like a team of like outside doctors and scientists and experts and stuff who...
Do they have those anymore now that RFK?
No.
I'm sorry. Well, I did not mean to interrupt.
Yes.
They do still have them, but almost, as far as I'm aware, a lot of the people who were on them were either are not on them anymore. So there's been a lot of turnover on those. But
Jake and Logan Paul and PewDiePie and all of the influencers are on those committees. Higher right, Chick. They're going to be blue ribbon.
Yeah, who knows? But basically, it's a team of people who, like in the example of the FDA, for drug approvals, will be a part of that process about whether or not to recommend the approval of certain drug, but then ultimately the people who decide it's the FDA review team. It's like the people who
Right.
actually work for the FDA. And so, there's that kind of body that you can create.
Mhm.
But instead, what Trump did after saying that there was going to be this outside advisory committee, on day one, takes an already existing entity within the executive office of the president that was known as the United States Digital Service. They were, mostly focused on things like software modernization and kind of improvement of technology within federal agencies. And he took that already existing component of the executive office of the president and renamed it and rebranded it as the United States DOGE service. And in this executive order, some of it did dovetail with what the United States Digital Service used to do, like with software modernization, all of that. But then also
Mhm.
it kind of gave a new purpose to this former organization. It did things like, saying that these DOGE people would have access to all unclassified records in the federal agencies. It in subsequent executive orders, it was like they're going to consult on things like hiring and firing of federal employees. All of the things that we've been seeing.
But still using the language of consult, not
Exactly. It's still
decision
using
making.
this language of like, it's going to be advising and consulting. And importantly, it also establishes these DOGE teams that are going to be kind of these like affiliates of DOGE that are out in the federal agencies that are technically employees of the federal agencies. And then it also creates the person who's in charge of all of this or mentions the person who's supposed to be in charge of all of this, who is this role called the administrator of DOGE. And, this isn't unusual. Most important federal agencies or departments or quasi-official bodies or components of the executive office of the president have administrators. And typically it's like a big deal to be named the administrator of some big deal government position like DOGE that has been this like critical part of the president's agenda that he's been talking about over and over and over again. And so I'm reading this and I'm looking at this executive order and I'm like, yeah, that's got to be Elon Musk.
Right.
And I think that everyone assumed that it would be Elon Musk. Everyone was saying that Elon Musk was the guy leading DOGE. And as the
Well, Elon Musk was saying
Elon Musk
Musk
was
is the one
saying that
leading
he
Doge.
was leading DOGE. And then you have things start happening. And what becomes clear is that this is clearly not just an advisory body that doesn't have a whole lot of power and they're just recommending things. You have Elon Musk literally doing a live stream in which he is talking about killing USAID. And he's, tweeting about like putting US aid through the wood chipper. You have this just massive body of public evidence that suggests that what the executive orders say that DOGE is doing is not really what DOGE is doing. And then B, you still have this like lingering kind of weirdness around the fact that Elon Musk in every way, shape, and form, and Trump, is bringing him into cabinet meetings where he's talking about accidentally canceling Ebola prevention efforts. And he's using the terms we, talking about him and DOGE as one, just all of this stuff. But then at the same time, the White House refuses to say who is the administrator of DOGE.
Yeah, so let me break in because I want to ask you why, this is a law show and we're all lawyers. Why would Elon Musk not want to be publicly, legally, in a court of law, the administrator of DOGE?
Yeah. So, Liz, this is when my legal reporter spidey senses like really kind of went on high alert when the White
Right.
House started to be very avoidant in terms of, and this is around the period of like early February to mid February when we just didn't know who was actually the administrator of DOGE. The reason why has something to do with the appointments clause of the United States Constitution. That's the main reason, but I want to get to some other reasons too after I discuss this reason. So, the appointments clause in the Constitution, first, as I've kind of alluded to previously, it establishes these like roles between Congress and the president in terms of creating government offices. So that's things like the federal departments that we have, the things like the Department of Defense and the Department of Education and the like all of the federal agencies that wield like a ton of power. The idea is that the people who are supposed to create those offices is Congress. And then the guy who's responsible for filling or appointing people to, run those offices is the president. And that division of labor goes back to the founders' experience with King George, who basically would just create these really powerful offices and then fill them with his own cronies, who would then go out to the colonies and like harass everyone with these very powerful positions that they'd been handed by the king. And so the founders didn't want that. And so what they did is they divided it up so that there's this, separation of powers that is kind of a check on the ability of the president to fill just these offices with a bunch of his loyalists and cronies. And the other way that they kind of handled that was by establishing a method by which once the president has decided who he's going to fill these offices with, for the ones that are really powerful, for the ones that wield significant federal authority, you have to go through a certain method or process. And this Constitution sets out those processes. One, as most people know, is for the most powerful positions, you have to have Senate confirmation. And then there's the kind of mid-level range of being a powerful federal official. And that's those people, usually the default rule is that you still have to have Senate confirmation, but the Constitution allows for alternative methods, like as long as Congress authorizes it.
Right. And this has a very funny echo, right? Because that's how Judge Eileen Cannon, in a sort of almost similar way, got rid of the Trump documents case, because she said Jack Smith was not confirmed by the Senate and was an officer of the United States. I believe there were a couple of
principal officers.
Right.
Yeah.
There were a couple of versions of this argument. I've forgotten the fine points of which one she bid on, but she said because Jack Smith hadn't been confirmed, the special counsel investigation didn't count and he couldn't be paid or some other crazy bullshit. And so it's sort of a funny echo that as soon as Trump gets into office, he tries to avoid this very issue, which he exploited to get rid of his other criminal or one of his many other criminal cases.
Yeah, I mean, it's ironic, right? That because the whole argument and Liz, yeah, that's a perfect example for people to understand why this matters. The general gist of it is that if you have the president who is giving someone a position that is, they are so powerful that they can do things like hire and fire federal employees. They don't report to any other cabinet members other than the president. They only report to the president. If they are calling shots that typically would be reserved for, people like the cabinet heads, then they probably are someone who should be confirmed by the Senate at a minimum. And, that's kind of the argument that Trump's team made when they were making this appointments clause argument before Judge Cannon, where they were like, Jack Smith has too much power and he wasn't confirmed by the Senate. So therefore, they had other arguments about whether or not he occupied an office established by law and that kind of thing that we don't need to get into the weeds on that. But that was the gist of it. Is if you have someone who's, just operating in a way where they're just wielding all this power, and there's two components of this. The Supreme Court has said basically, if you are an officer who A, wields significant federal authority, and then B, occupies a continuing role in the federal government. And continuing doesn't mean he was only here for 3 months. Continuing means like the role is not personal to them. So
Right.
a good example is the administrator of DOGE position in the executive order is not, it's not saying I am creating.
It doesn't have an expiration date.
It doesn't have an expiration, right? Like it's just like I'm creating this role that could be occupied by any succession of various people, no matter who they are. And so this gets me to why it matters.
But before you get there, I just want to make sure that I'm putting the pieces
Yeah.
together correctly, because I think I've read you right. And that is that certainly if you begin with the formulation of law as articulated by Judge Eileen Cannon in Florida, but even if you're looking at actual law and actual precedent, whatever the powers are, if Jack Smith, as a special prosecutor appointed by the Attorney General with a uniquely delimited set of responsibilities over a specifically delimited investigation, didn't have an expiration date, but that position didn't continue after Trump, was indicted, or in this case, the cases were dismissed and the final report prepared. If that's a principal officer, if that requires Senate confirmation, the advice and consent of the Senate, then clearly whoever the administrator of DOGE is requires approval, the advice and consent of the Senate. Do I have you right on that?
Right. And I will, look, I said we don't need to get in the weeds, but I will add, like, Judge Cannon's decision is distinguishable from an Elon Musk DOGE situation too, because one of the issues there is this question about whether or not there was statutory basis. Congress authorized the appointment of special counsels. There was a statutory framework that in my reading, and even in the Supreme Court's own reading in Nixon, the Supreme Court said, yes, under these statutes, special counsels can be appointed. And there was a regulation that was set out under these statutory authorities that provided for the appointments of special counsels who did, the role that Jack Smith did. And Judge Cannon, of course, in my view, again, wrongly, very wrongly, said, oh, no, like these statutes didn't authorize this. And so that's, one reason why it's distinguishable. But yes, you're in the general kind of idea of like, you've got a guy who's too powerful. And if it's the special counsel who you said was too powerful, then surely the guy who's canceling Ebola prevention efforts and demolishing U.S. aid, which is a congressionally established, agency or appropriated agency, then surely that guy also has to be someone who should be Senate confirmed.
Okay, hold that thought. We're going to take a quick ad break unless you're a subscriber at patreon.com/lawandchaospod or lawandchaospod.com, in which case, no ads for you ever. And we're back. Okay, Anna, you were making a point about Elon Musk and the appointments clause and why it matters. Who's in charge here?
Yeah. So again, and remember, this is around the time of mid-February when this massive project and key part of the president's agenda, DOGE, is doing all these things. They're dismantling USAID. They're, taking over federal agencies. They're doing all of this stuff. It seems like Elon Musk is in charge. They're saying that Elon Musk is in charge. And it seems like someone like Elon Musk is wielding significant authority without having been confirmed by the Senate. And that seems like it might be an appointments clause violation. And so there were a few organizations that filed suit in mid-February. One was a coalition of states, state attorneys general, excuse me. And then another, a group of nonprofits. And then there's also a case that was brought by former and current USAID workers. So you have all these cases that are kind of piling up that relate to this question about whether or not Elon Musk is, as the head of DOGE, exercising unconstitutional authority by doing all of this. And the reason why these cases are being brought is because, if you have an appointments clause violation, it's possible that that thing that was done, whether it's, taking down USAID or firing a bunch of workers or whatever, could be found to be unlawful and therefore ultra virus or outside the law and could be void. It could be taken back as a result of this finding that there's an appointments clause violation. And so this is like a really consequential question,
Right.
is the question of like, who's occupying the role of the head of DOGE? And
Yeah. And Anna, but before we can you unpack a little bit, right? Because the three of us are lawyers, so you said void ab initio. We all get it. I mean, talk a little bit about what happens if an executive branch agency, if there's a judicial determination that the person making the decisions was not appropriately approved by the Senate, and they were required to be. Like, what happens in practical terms?
Yeah, so in practical terms, like there's a few things that could happen. Like, let's say that you have this finding. One thing that can happen is that the thing is void and it has to be undone. Basically, there
there's precedent for that.
There is precedent. There's there were a few appointments, including the Ken Cuccinelli appointment. There's also, who was it? Was it Wolf?
Yes, it was Wolf.
Yeah.
At the Department of Homeland Security. Just to jump into kind of remind everybody who isn't all the way up the ass end of all of the Trump administration happenings, the Trump administration did not want to submit all of its nominees for Senate approval. And so it just sort of stuck people in there in an acting capacity. And that had all of its like statutory implications having to do with the Federal Vacancies Reform Act and all kinds of other things. They were sort of time limited and authority limited. And it was really, in many of these instances, if the position was vacant, the deputy would by statute take the position, but Trump didn't want the deputy. He wanted, some goon. And so he would stick these people in there. And in one specific scenario, I think it was the Chad Wolf scenario, because there were too many actings who were not legally appointed at the Department of Homeland Security. Some of the things that they did in these illegal appointments were later deemed to be not legally valid and thus to have no effect.
Yeah. And so you have that example. So one thing I will mention, though, is that, another thing that can happen in addition to these actions having no legal effect potentially is that there's at least like maybe they end up having some effect, but there might be some kind of like additional process that needs to be done. So one thing that we've seen even more recently in the USAID case that was brought at the district court level, one of the judges, he initially found, Judge Chuang in the District of Maryland, found that, like Elon Musk was acting as the de facto administrator of DOGE. He was acting as a principal officer of the United States in violation of the Appointments Clause because he wasn't confirmed by the Senate. And he did some things that, through DOGE that were basically outside the law, or ultra virus, as the term is used in Latin. But I believe it's Latin, right? Yes.
Mm-hmm.
Okay, good.
Yes.
All right. And so the judge said, but I'm going to give you an opportunity for some of these things to have 14 days for the appropriate agency authorities to actually kind of ratify or like approve of these actions.
Mm-hmm.
And this is one of the things that is an issue in some of these appointments clause cases, and very well could be an issue in the future, is the fact that courts have said, if there's ratification or approval, even after the fact, by people who do have the appropriate authority to make some of these decisions, then it doesn't necessarily mean that, the decision is taken back or that it doesn't have any legal effect. But, sometimes like even having that additional process is important. And there's also the fact that we really don't know if some of these really unpopular decisions that have been made by DOGE would be ratified by people with authority. I think that cynically, I would think like, yeah, probably.
The Senate hasn't shown a lot of backbone to date.
Yeah, well, and it's that, and then, but also like people like Marco Rubio, who used to be a big USAID proponent, is has been a person who has acquiesced to this dismantling of the agency, and so he's one of the people who would have constitutional authority to approve some of these decisions that were being made around USAID, for example. And so it's, even though I'm cynical about these questions around like, are any of these officials going to be hesitant to ratify these decisions, these unpopular decisions that were being made by DOGE, it's still like, if a court ultimately decides like, yeah, Elon Musk was doing this and he didn't have the power to do it, and I'm going to give you a chance to ratify it, it could very well be that some of these decisions are not ratified and so then, cannot take legal effect.
Oh, I see.
So anyway, point is, getting around to the kind of ultimate peak of my villain origin story, the examples that we talked about with like Cuccinelli and Wolf, like those are examples where the administration was trying to get around the appointments clause, but they were still at least admitting like, oh yeah, like these are the guys in charge. Like they were trying to do it by putting them in acting roles or whatever. But they weren't.
And that was Trump's first term.
That was Trump's first term. And they weren't, but what they weren't doing was saying like, oh, these aren't the guys who are really making these decisions. They were admitting like, oh yeah, these are the people, acting under color of some kind of official title. Instead, what we have here, and the reason that I've kind of lost my mind over this question is you have in public, Elon Musk seemed to be doing all of this and was acting as though he was the head of DOGE. You had the president of the United States who literally said, on my first day in office, I created an executive order establishing DOGE, and I put a man named Elon Musk in charge. You have these public statements like that. Meanwhile, in court, by the end of February, we had a declaration that was submitted by the Justice Department in which they said Elon Musk isn't the administrator of DOGE. He isn't even an employee of DOGE.
And why would they not want to say that? I mean,
And again, the reason that they wouldn't want to say that he is the administrator of DOGE or even an employee of DOGE is in part, I think, because these appointments clause cases have been filed like 5 days earlier before they submitted this declaration. And it's not, it's helpful to just have Elon Musk be further removed from DOGE as much as possible, because now it's like the plaintiffs have to argue that he's the de facto head of DOGE, even though the White House eventually says, oh no, this other lady, Amy Gleason,
who was on vacation at the time.
Yeah, right. You want to talk about Amy Gleason?
Yeah. So after I start like losing my mind over this question, who is the administrator of DOGE? The White House wouldn't say. They said Elon's not the administrator. They said he's not an employee. They were clearly trying to create a degree of separation between Elon and DOGE. I'll get to some other reasons for that. But, at the time, the big focus was like the appointments clause question. And they, about a week after I'm asking about it, federal judges are asking about it. Justice Department attorneys are like, we don't know who the administrator of DOGE is. Mm-hmm. And keep in mind, these are the people who are defending DOGE's actions in court. Like these are the guys who are going in to say, oh, no, everything DOGE is doing is lawful. And they don't even know. When asked by federal judges who the administrator of DOGE is, reporters start asking about it. And then finally, the White House comes out and says, the administrator of DOGE is Amy Gleason. And she is a woman that publicly no one even knew really was affiliated with DOGE. She previously worked for the United States Digital Service, which is the old DOGE. She left government to work for a guy named Brad Smith, who is one of Elon Musk's kind of top lieutenants at DOGE. And then she was brought back in to government service with Brad Smith and had been, working at DOGE. And they announced that she is the administrator, and yet we are still getting public statements, like even within a span of a few days, in which Trump goes out and says to like Congress that Elon Musk is the head of DOGE. And so there's not only this appointments clause question, there's also this question of like candor to the court, that lawyers have an ethical duty to not mislead the court, to be candid. And so you have this question about what happens to that ethical duty when you've got one of your clients going out and saying things that completely contradict the kinds of things that you're, filing in court, in which you're saying, oh, no, Elon's not a part of DOGE. And then, Liz and Andrew, there's this whole other separate question in which that relates to some of these other cases about DOGE. And one I want to mention is about FOIA. The way that the government has tried to shield DOGE from transparency, even as Elon Musk has claimed that it's the most transparent organization or department in the history of government or something like that. One way that they've done it is by essentially saying, oh, DOGE is just advisory. Look at these executive orders. That everything that DOGE is doing is just advisory. And so therefore, it's not an agency under FOIA, and that has a very specific meaning under the Freedom of Information Act. Typically, things that are within the executive office of the president, which DOGE is, and things that are just—
even by their admission.
Yeah, even by their admission, things that are just like only advise the president and make recommendations, those kinds of entities within the executive office of the president, they typically are exempt from FOIA and instead are subject to the Presidential Records Act, which essentially, the requirements are very different. It'll be like years before we get any information.
Right.
It is subject to the PRA. And so there's this question of like, is DOGE just advising, or under FOIA, is it an agency that, again, this question is like whether it wields significant independent authority. And the government has tried to shield DOGE from any real scrutiny by saying that it's exempt from FOIA because it is just advisory. And then I think, too, that, and a part of that question involves this question of DOGE's chain of command and what it's actually doing and like who is making these decisions. And there's been litigation filed over this, including by CREW, which is government watchdog group. This ultimately has recently gone up to the Supreme Court over a discovery order in which a judge made a pretty favorable finding saying that, no, DOGE, I don't think is just advising. But essentially, this question goes to a bunch of these questions that are kind of wrapped up in this who is the administrator of DOGE question, which is basically just like a proxy for like all these other inquiries of like, what's the chain of command? Who is really in charge? What's the structure of DOGE? We don't even know because there's no organizational chart. And these are things that people should know. Like it's an organization that is like dismantling the federal government, and yet we don't even know the answers.
Yeah, has sent out draft notices to various government agencies instructing them on how to terminate 90 to 100% of staff, right?
Yeah.
Like these are crucial decisions. Sorry, I didn't mean to cut in. I just wanted to emphasize that.
No, and so like the gist of it is just that like there are several different things that this question represents, which is just overall kind of why I've been losing my mind, because they're crucial to these legal cases, and I think that a lot of people don't quite understand why exactly it is important to track these statements that the government is making in public that it's then contradicting in court. And it all goes to these questions of the legal cases, because the government is saying, no, courts, just look at what is on paper. And on paper, Amy Gleason is in charge. And on paper, DOGE is just an advisory body. And so you need not look any further. But in fact, if you look at what's the facts are on the ground, there's a heck of a lot of evidence, overwhelming evidence that says otherwise. And so I think that's why I kind of got into really being obsessed with this question.
Right. And multiple courts said, clearly this is an agency. It is not part of the executive office of the vice president, and granted discovery and ordered the government to kind of submit to discovery and to behave in ways that the government did not want to do. The Trump administration did not want to do. The Trump administration did not want to disclose, like, for example, the org chart or, who gave the go ahead for these orders, who called the code red as we all would remember from that movie. And so what happened at the Supreme Court? Because a lot of the courts said, yes, do it, go ahead with discovery. And in fact, most of these were in DC, and the DC Circuit did agree, but the Supreme Court did not.
Yeah, I mean, so the Supreme Court, this is one of the most recent decisions that we got within the last week on this question. One of the things that the Supreme Court said is basically, this is a separation of powers issue. It seemed reluctant to allow this inquiry into because again, keep in mind, the government's position is that DOGE is just making recommendations. And a part of this discovery order that the lower court ordered was what recommendations has DOGE made? And then, to what extent have the agencies followed those recommendations? The reason why the plaintiffs in this case wanted to know that information on this question of whether or not DOGE is subject to FOIA is because they recognize, and the judge did too, that there's a really fine line that's being walked here with the line between recommendations and directives. Again, DOGE might be saying that it's just giving recommendations, but if the recommendations are always being followed, doesn't that kind of suggest that maybe these aren't just recommendations? They're more like directives. There's allegations and other litigation that, these are recommendations. If these are recommendations, they're being made basically under kind of some kind of duress or threats, basically, that if you don't follow this, you're kind of going to be out, or there's going to be some other consequences.
Okay, Anna, hold that thought. We will be right back after this brief ad break, unless, of course, you are a subscriber over at patreon.com/lawandchaospod or on Substack at lawandchaospod.com, at which point no ads for you ever. And we're back. Well, we saw that in the very first week when they got access to the internal government emails, and they sent around, that fork in the road email to 3 million government employees, including sitting Article 3 judges who have tenure for life, demanding that they respond to that email or, face immediate termination. So I think in addition to the discovery on who's making the decisions, who's making the recommendations, discovery as to the content of those internal communications is going to, we all know this, we're avoiding saying it, it's going to show that they are directives, not recommendations.
Yeah. And I've written pieces that are about emails that just people are saying, we got a direction from DOGE that XYZ. So it seems like they are directing rather than just recommending. But the Supreme Court seemed to take the government at its word in this order that it issued, because even though the lower court judge in the discovery said oh yeah, these recommendations, we should have some discovery on it because there is this fine line between directing and recommending. It went to the DC Circuit. The government said, oh, this is a separation of powers violation, even though they didn't even really bring that up when they were objecting to the discovery at the lower court. Right. So the DC Circuit was like, you waived this, but even if you didn't, we think that, this discovery can still go forward. goes up to the Supreme Court, and the Supreme Court says, as we've learned from the immunity decision, it seems like there's nothing more that John Roberts hates than people looking at advice that the president is getting from his people, and that was very much in line with what the court said here, in which it was like, the courts need to have respect for the separation of powers in terms of inquiring into the recommendations that the president is receiving from an executive branch body. And so they sent it back down for the lower court to consider this question about how the discovery can be tailored to kind of have more deference to the executive branch and the separation of powers. So it doesn't mean that we're not going to get any discovery on this question around what DOGE is and whether it is subject to FOIA, but it certainly does not bode well for the question of, whether the court will be willing to look beyond just what is on paper and actually what's happening in practice with DOGE.
Okay. So now I want to ask you about the funnest day on the internet in a long time, which was when Elon and Donald Trump broke up.
That was a crazy day.
Yeah. Did you think that they were faking it when he said he was leaving until you saw Elon Musk be like, guess what? Trump's in the Epstein files. Dun, dun, dun. Or did you think he was really on the way out? Like, I think he's out now.
I think he's out now. I had my suspicion, like it was really hard to say because honestly, again, I'd been so obsessed with this question where there were so many statements that publicly they were saying one thing, in court they were saying another. There were so many contradictions that it was kind of hard to tell whether Musk, when he initially announced that he was leaving, was it the case that he's actually leaving? Like, it seemed convenient that he was saying he was leaving at a time when these legal cases were really heating up, at a time when Tesla's share price was really going down, at a time when, his special government employee status, which only allows him to work 130 days out of a 1-year period, was about to be up, or seemed like it was about to be up. And so it was kind of this, lingering question of like, is he really going to be gone? Then you have public statements by like the vice president who's like, oh, he's still going to stay on as an advisor. And Musk is saying like, DOGE is like Buddhism. Like, it's a way of life. It's all these weird things that you're just like, okay, I feel like he's not maybe really leaving. And then we got the best day on the internet. Right. And finally, that day, I think, resolved because you have this big blow up between Musk and Trump that, whatever, maybe it's been resolved a little bit now. But at the very least, what you have after many months of these contradictory statements about who is actually in charge, you finally seem to get some clarity on who is in charge of DOGE, in that, like, Musk is saying he's not in charge. The president is saying he's not in charge. The lawyers are saying he's not in charge, all at the same time. And then also there's this big public beef between them. And so finally, it seems like we can rule out that currently Elon Musk is the administrator of DOGE. Maybe. But
I have a theory as to who is actually the administrator of DOGE, and it is Grok. Grok, the AI that it lives in Elon Musk's fillings or whatever it is. It is the XAI, the Twitter AI, that it notoriously hallucinates a lot of crazy shit, and then Elon Musk gets mad at it when it says things that are true, and then it stops saying those things. But I'm only half joking. One of the reasons which I believe they were so squirrely about trying to hide what they were doing is that they were doing so much of it via AI. You've had people who were in Doge and out of it saying, well, we just sent AI to crawl over these contracts and, zero out or munch them is one of the terms that they were used, decide which ones were munchable, get rid of things, and which does not, in my I suspect that there will be a strong argument in court that letting an AI decide whether a contract is, useful to the federal government does not. You're canceling a contract. That's arbitrary and capricious, which is one of the reasons which I suspect that they were so aggressive about not submitting to discovery, is that so much of what they did was accomplished by setting AI onto massive data sets that contained classified data and possibly not, or at least protected data, and possibly not shielding that data, that all kind of lives in the AI now. But before we go, I really want to ask you, why does it matter now if Elon Musk is out? Why does it still matter who the administrator of DOGE is? And maybe also, what do you think is going to happen? Is DOGE really is the government sort of DOGE Buddhist now, or what's going to happen here?
Yeah. Okay. So look, it still matters because even though you have, look, the who is the administrator of DOGE question, isn't just the one question. Like I've said, it's kind of like a proxy of question, or a proxy for a bunch of different questions that relate to DOGE. But B, it's not just concerned with this contemporaneous question or present tense question, who is the administrator of DOGE? It has always been the case that as soon as these legal cases were filed, it's always been a backward looking question of who was the administrator of DOGE at the time that this relevant conduct occurred. So in the USAID case, for example, when the agency was shut down, when everyone was laid off, when the sign was taken off the building, all of that stuff that predates the fact that there is now a formal on paper administrator of DOGE, Amy Gleason. So it's always
she's back from vacation.
She's back from vacation, maybe. She has been appearing at some HHS conferences because she has a dual role. She moonlights basically at HHS as an employee there, which seems really,
obviously.
It seems really hard.
There are only 7 people in this entire administration.
Yeah. But so it's always been backward looking because in litigation, it's about here's what we're saying that you did at this time. And so then the question is who was in charge then? And we now know from one of the depositions and some of this litigation, there was one DOGE person who was deposed in a case. And it's not one of the appointments clause cases, it's a different case. But this person who was supposed to be the representative of DOGE, Kendall Lindman, who's also a person who is affiliated with Musk companies, testified in this case. And at one point they ask who, was the administrator from February 5th to February 18th. February 18th is when Amy Gleason was announced or appointed as the administrator. And the person says there was no administrator of DOGE at that time. And so we know that at least during a critical period when DOGE was doing a bunch of stuff, it didn't have a formal head. And so it makes it all the more important to ask this question, a version of the question I've been asking, which was who is the de facto or the real administrator of DOGE during that period? And then finally, it's all right, we can finally maybe rule out Elon in terms of the present tense question. But what does that mean for who is running DOGE now? And what even is DOGE going to become now? We've already seen some statements in which there was this statement by an official who said all the cabinet heads are in charge of DOGE now. And so it's everyone's in charge of DOGE. And then there's recent reporting that it's going to be this guy, Joe Gebbia, who will lead a team of advisors who will be in charge of DOGE. It's all just very again, the question persists in terms of who is actually leading this entity that is making massive decisions around that affect Americans' lives and that of the federal workforce. Because even though Musk is gone, and there may be beef, some of these DOGE people are now have become full-time employees of the federal government. And so I do think that the DOGE kind of attitude will persist because there's been so many different DOGE affiliates and Elon Musk allies who have been embedded in these federal agencies and in DOGE.
DOGE will never, ever die. DOGE is the light. DOGE is the force. The DOGE must flow. Okay, Anna Bauer, thank you so much for being with us today. This was super.
Thanks so much.
And thanks again to Anna Bauer for a great interview. Maybe the real administrator of DOGE is the friends we made along the way. All right. We'll see you guys in a couple of days with written content on Thursday. And as always, a podcast on Friday. See you guys.
Law and Chaos Podcast is a production of Raise Ipsa Media, LLC, is intended solely as entertainment, does not constitute legal advice, and does not form an attorney-client relationship. This show is researched and written by Liz Dye and produced by Bryce Blankenagel. Law and Chaos Pod, copyright 2024, Raise Ipsa Media, LLC, all rights reserved.